CRPA is throwing its hat in the ring in another case in the form of an amicus brief. This is U.S. versus Kitson, making sure that the Bruen decision is being applied appropriately to a Second Amendment challenge. Let's talk about it. Hey everybody, welcome back to the channel today. A little bit of a different setting, but the same arguments that certainly will ring true. We've got the U.S. versus Kitson case here. That is a criminal case. But to talk about it, because CRPA, along with a couple other organizations, have filed an amicus brief for this case. To talk about it, we've brought on an attorney at Michelle & Associates. That is Kostas Moros. Kostas, thank you for being with us today.
Kevin, thanks for having me on again. Always a pleasure.
Absolutely. But before we get into that, guys, please be sure to like, share, and subscribe to these videos. It can directly affect Second Amendment litigation and legislative activities here in California, not just for the CRPA, but to get the algorithms to spread this message wide, make sure people are informed when they go to that ballot box in November at the end of the year for the general elections. Also, be sure to hit that notification bell so that as we come out with these videos, you are the first to know so that you can also spread that message wide. So, Kostas, let's sort of jump into this. Like I said, this is a little bit of a different setting. Same arguments, though. We've got a criminal case here, U.S. versus Kitson. Can you go ahead and just set the stage for us? How does CRPA come to the point where they're filing an amicus brief that started out as a criminal case?
Sure. Well, what we saw in Kitson was the district court completely fumble, either intentionally or negligently, the Bruen analysis. The district court didn't follow it at all, and that's what caused us concern, because whether we like it or not, criminal cases make case law. We saw that a couple weeks ago with the Duarte ruling, which came out of nowhere, in part because it's a criminal matter, and us and other organizations are mostly focused on civil matters. So it's important to keep track of these criminal matters to the extent we have time and are able to, just because sometimes you see things like this that make you want to correct the analysis, even if you don't ultimately change the result, because getting the analysis right affects us too, not just Mr. Kitson and not just other criminal defendants.
So what is the actual case here in U.S. versus Kitson? What exactly happened? This is a case where we're directly commenting on machine guns. How did this case get to the point where it's at now?
Well, Mr. Kitson, he was attempting to transfer a historic. My understanding of the facts is he was helping facilitate the transfer of a historical machine gun, a PPSH 41, which is from the early 20th century, which that gives you a clue right there that the prosecution might be a little silly, because even if it's an unregistered machine gun, I don't think anyone's going to be trying to commit some crime with, basically a museum artifact at this point. It's an old gun. I'm sure it still works and is still effective, but the gun, it's not some modern, M4 or something. So he got caught. He tried to sell it, I think, to a undercover federal agent. So that's what got him in trouble here. And one of the arguments they're making, among others, because they're also making technical arguments around the application of the law, but they're arguing that the Second Amendment, the public defender is arguing that the Second Amendment makes 922 the law that bars the transfer or possession of unregistered machine guns. They're saying that is unconstitutional.
Okay, yeah, and so as far as the amicus that CRPA has filed, it has several major points, but before we even get into that, there was something at the onset of the amicus brief that I wanted to discuss with you. Jacob, if you could actually pull this up on the screen. Guys, I know it's a little bit of a mouthful, but I think it's going to be worth it. So, Kostas, just in the title here, brief of Amici Curiae, California Rifle and Pistol Association, Second Amendment Law Center, and the Second Amendment Foundation in support of neither party and reversal or remand. And then if you go down a little bit, Jacob, if you could pull this up on the screen as well in the introduction. Amici are Second Amendment advocacy groups that focus on civil litigation to advance the rights of their members, law-abiding and responsible citizens. They do not typically advocate in criminal matters like this one. They do so here because the district court's ruling was striking in the degree to which it refused to conduct the historical analysis required under New York State Rifle and Pistol Association v. Bruen. That was a critical error that the amici urged the court to correct. In doing so, amici take no position on whether appellant himself may possess firearms because this law prohibits anyone from possessing or transferring an unregistered machine gun, whether or not they have a prior conviction. They also do not take any position on this stage on whether this law is constitutional. Under Bruen, that question can only be answered with a proper analysis examining the historical tradition of restrictions on dangerous and unusual weapons and determining whether machine guns fit that tradition. The analysis may not be skipped by misconstruing Bruen as a two-step test, nor by declaring the machine guns are not arms, nor by limiting the scope of the Second Amendment only to firearms types that are most commonly used for personal defense. So, just really quick, I mean, that kind of puts the three main topics of the brief that I want to discuss about with you later. But just from the onset, it seems like there is a concerted effort here to make sure this is not in support of the person himself. It's in support of the Second Amendment and the way that the court looks at the Second Amendment. Is that distinction necessary here? You know, it also kind of makes me think about the Rahimi case where the Second Amendment community hasn't really been shy about saying, we can make good law here. Doesn't necessarily mean that the person in the criminal case is a good person. So how exactly do you make that distinction as you go forward? Is it worth making that distinction in the court?
Yeah. So first of all, I want to say that my memory's failing me on Mr. Kitson's exact past crimes, but if I recall correctly, I don't think he's comparable to Mr. Rahimi. So I don't want to disparage the man and say, he's a domestic abuser like Mr. Rahimi is. I don't think it was anything like that. But yes, in general, the reason we opted to say it's probably the most unusual title of an amicus brief that I'll ever do, because we're saying it's in support of neither party, but we also urge reversal and remand, which sounds like it's in support of Mr. Kitson. And the reason we came to that conclusion is because we don't ultimately take a position on whether machine guns may be banned. I think the analysis we lay out probably leans against them being able to be banned, but we concede that ultimately a court needs to do the historical analysis in full, follow Bruen, and only then can you actually decide that question. So that's why it's in support of neither party, because ultimately the result is if we had come out and said, no, you can't ban machine guns, for sure, then that would be in support of Kitson. But because we take no position on that ultimate question, then it's in support of neither party. But the reason we urge reversal or remand is Mr. Kitson argues reversal is proper because the government had a chance to present its historical laws and only presented two historical concealed carry laws, which were not at all similar. And they're basically saying, you had your chance, so this should be reversed. And we think that might be correct, but ultimately, if the Ninth Circuit decides that they won't do that, and I have to admit here, I'm not usually a criminal defense attorney, so I'm not sure if the procedure allows for this, but ultimately they could also remand it back to the district court and say, do the whole historical analysis, and then we'll take the look, after that result. So that's ultimately what we think would be the correct procedure. And again, the analysis matters. So that's why we urge that.
And I guess just to clarify, yeah, I was not trying to say that the two were the same. Just sort of reminded me of the Rahimi case, just because they're both criminal cases. But thank you for clarifying that. I do appreciate that. I guess also really quick, is there anybody in the judicial system that might think that a criminal case shouldn't be viewed through the lens of Bruen?
I'm sorry, do you mean whether Bruen should apply to a criminal case?
Yeah, is there any difference between a civil and a criminal case to where somebody might make the assessment that even though we're talking about firearms or Second Amendment rights, that the Bruen decision shouldn't be applied?
Well, I mean, it's supposed to apply to any Second Amendment challenge, So, I mean, ultimately, a court might think the Second Amendment challenge is frivolous or that plain text is not implicated or something like that. But anytime, whether it's a civil or criminal litigant, if they're saying, we're challenging this law that either we don't like if it's a civil litigant or we were convicted under because we're a criminal litigant. If you're a criminal defendant and you say, I was convicted under this law, but this law is unconstitutional under the Second Amendment, Bruen must apply. And there's no skipping that. And that's part of the problem we had with this case. Yeah.
Right, and I guess the reason I ask is just to make sure, that this is more of the same of what we see, whether it's not necessarily understanding Bruen or trying to get around it as a whole. I don't think that there's any real notion out there that Bruen shouldn't be applied just because this is a criminal case. But reading through this, nonetheless, the arguments get kind of weirder and weirder. We already kind of touched on those three topics, but I'm hoping you can get into them for us as a refresher. Those three main topics on the brief itself was that the Second Amendment analysis under Bruen is a one-step test, not a two-step test. That machine guns are arms and therefore must submit to the Bruen test when in a claim like this. And then you also have the military's use of firearms does not disqualify it from Second Amendment protection. Can you break these three topics down for me, and I guess why they are being clarified in this brief? What is it that's already been said in this case to the point where you need an amicus to clarify these things?
Well, sure. You can read the district court ruling in Kitson in about 2 minutes. It's that short. The Second Amendment analysis will probably take you about 90 seconds to read. It's very short. It didn't apply Bruen at all. I mean, it ostensibly did, but it basically pointed to pre-Bruen Ninth Circuit case law that said machine guns could be banned, and that was it. There was no further historical analysis, and so we think, let's start with the first one, the plain text. That one is a question that has divided a lot of people. I'm in the camp that Bruen is a one-step test because you had, for example, Justice Thomas saying in the Bruen ruling, the old two-step test was one step too many, and you're supposed to have historical tradition decide these questions. So now you have courts making a new two-step test in which first you have to establish that you meet the plain text of the Second Amendment, and only then do you do history. The problem is, of course, that obviously you have to meet the plain text, but that's not a deep analytical step. We don't look at First Amendment cases and argue for page after page whether somebody saying something is speech. It obviously is. I think what the plain text analysis, to the extent there is any, is just, is this about people buying, training with, etc., arms? Like, is this about a person and a gun, or anything else that could be defined as an arm? And if so, you do the historical analysis. And some historical question analysis might be very short. For example, if this is a dangerous individual, if this is a violent felon and he's suing to have his gun rights back, that might be a very short historical analysis. You just point to a few historical laws disarming dangerous people and you're done. But you don't skip it altogether. And what the plain text what this supposed first step has done is it allows governments and courts, for that matter, to sneak back in the old interest balancing under the guise of a plain text analysis. So, for example, I was just working on another brief yesterday in California's preview of things to come, I guess, but the one gun purchase per 30 days law. We're doing an amicus for that probably. And one of the things the state argues in that case under the plain text is, well, this law doesn't stop anyone from having arms. You can buy your one gun, then you just have to wait 30 days for another. And so the plain text isn't implicated. But that's just interest balancing. What you're saying is the burden on the person isn't a big deal compared to the state's need to stop people from buying too many guns. That's just interest balancing, and they've put it under the plain text. So that's why we think that Bruen ultimately is a one-step test. Yes, you first check to make sure that obviously this is a case about guns. That's not a frivolous claim of Second Amendment application. But once you have that, you go to history. And we saw this in Duarte. So Duarte is a great ruling, but it talks about the two-step test as well. And even in its first step on who are the people, it did this deep, like 3-page historical examination. So that just goes to show that even in the supposed new two-step test, they're still doing history if they're going to actually figure it out. So again, Bruen is a one-step historical test. The Supreme Court might be about to make me look like a fool in Rahimi if they endorse this two-step test that appellate courts are doing. But at least for the next few weeks, I will die on this hill. We'll see what happens.
And then what about the military's use of firearms not being disqualifying, and under what circumstance could you imagine somebody doesn't think that a machine gun is an arm?
Yeah, actually, I'm going to step back one first, and then I'll answer that question. The second one is machine guns are definitely arms, and that's part of the military question is an aspect of that. So another thing the district court seemed to assume, if you read between the lines, is, oh, the Second Amendment only applies to guns used for personal self-defense. And obviously, any gun can be used for personal self-defense, but what they mean when they say that is most applicable to that. So your handguns, your pump shotguns, these are things that exist mostly for personal defense as opposed to combat. And that's not in the Second Amendment, and that's not in any case law. So what the Second Amendment says is that it applies to arms. And according to Heller, the dictionaries that were cited in Heller from the founding era, they talked about armor of defense or weapons of offense. So armor is covered, and also weapons of offense are covered, not just personal self-defense. So that doesn't mean, by the way, that you can't restrict certain arms for if they're dangerous and unusual, which the brief gets into. So, but they are arms, right? You can't just disqualify them at the plain text that because by saying they're not even covered arms. They are arms, and maybe they might be dangerous and unusual, and then you can restrict them. But you do have to go to that historical step then. Or the historical review. So now turning to the military thing, another thing we've seen courts do, especially the Seventh Circuit in Bevis, which we're hoping the Supreme Court will grant cert on, is they basically said, and we think this district court might copy them, is essentially that arms that are used by military police are not covered by the Second Amendment, which is an insane standard. That would mean that muskets in the founding era are not protected arms because they were used by both the British and the Americans during during the Revolutionary War. So it's never been the case that people can't own weapons just because the military has them. I think the best way to draw this distinction that I've seen is Judge Benitez's ruling in Duncan and I think Miller, where he said an arm used by the military doesn't mean it's not protected. However, weapons that are only used by the military probably aren't protected. So that would be, your stealth bombers, your warheads, that kind of stuff. Those are certainly dangerous and unusual, and they're probably not even bearable arms anyways under the definition of the Second Amendment. So I think that's the best way to draw that distinction. So we go through in our brief the history of, both historical commentary and some other cases about how people up through the late 19th century essentially said that the Second Amendment protects combat arms most of all, because one of the purposes of the Second Amendment is not just personal self-defense, but societal self-defense against a tyrant, a foreign invader, that kind of thing. This was very big in the founders' minds because they had just fought a revolutionary war against a tyrannical government. So it's just completely ahistorical to suggest that the Second Amendment does not apply to firearms that would be useful in combat. Of course, self-defense is, especially in our modern society where we feel pretty secure and aren't too worried about currently a tyrant or a foreign invader. Of course, we think personal self-defense is more important. But as other countries like Ukraine, like Israel and others have discovered, that can change in an instant. That sense of security isn't guaranteed forever. So that's why the Second Amendment, like the entire Bill of Rights, is supposed to be timeless. It's supposed to apply to more than just the circumstances we currently live in. So I think I'm rambling here, but I think I got the point across.
Yeah, definitely, and definitely a case to follow along with to see if the standards of Bruen can continue to be upheld, whether it's in a civil case or a criminal one. Kostas, I guess just to round this out, what are your thoughts moving forward here? Not just with this case, but in general. Do we start seeing a lot more participation by organizations like CRPA on criminal cases now that we have the lens of Bruen to look through for Second Amendment rights?
I can't speak to what other organizations are going to do. I know that, look, ultimately our cases that we litigate have to be our first priority. So I can't promise, even on many other worthy criminal cases, that we'll do an amicus brief. But when we have time, when resources allow, we will try to do more of them. And look, for if any members out there feel queasy about supporting criminal defendants, a lot of constitutional law, a lot of the rights you have protecting you come from this. Your Miranda rights, for example, everyone hears those in movies. You have the right to remain silent, etc. That comes from a guy named Miranda in the 60s, a criminal defendant who was a complete scumbag. Look him up. Total scumbag. And yet we're glad that case happened because it established these constitutional protections that that everyone enjoys to this day. So, obviously we would look at each case closely and we would determine whether not every case would benefit from our commentary, but here we think, hopefully, depending on who the panel is, because if we have a bad panel, it's a lost cause anyway. But hopefully, depending on who the panel is, they give our amicus brief some serious consideration. And we'll be on the lookout in the future as time allows to do more of these sorts of briefs.
Absolutely. Well, as always, Kostas, I appreciate you coming on. I know that you're a busy guy. You got a lot of stuff to do now that you're getting into this as well. Definitely something that we're going to be following along with. But I want to thank you for coming on and taking the time with us today.
Always a pleasure, Kevin. Thanks for having me.
Absolutely. And guys, if you like content like this, want to learn more about the ways that CRPA is advocating for Second Amendment rights in the legal world, please be sure to like, share, and subscribe to these videos. Hit that little notification bell so that as we come out with these videos, you are the first to be notified. Until then, thanks again, guys, and we'll see you on the next one.